First case that we have this morning is State v. Michael Howard. And we'll just do what we normally do. If you can please state your name and readiness to proceed.
Angela Glazer on behalf of defendant appellant Michael Howard. I'm ready to proceed, Your Honor.
Good morning.
Good morning.
Mary Steer on behalf of the state, ready to proceed.
Good morning.
Morning.
So Attorney Glazer, would you like to reserve some time?
Yes, Judge. I'd like to reserve 3 minutes of rebuttal time, please.
All right, no problem. Whenever you're ready.
Okay. May it please the court, Ms. Steyer, Mr. Howard's family, if they were able to log on this morning. Judges, I'd like to start with the second assignment of error in my brief. And essentially what I'm arguing there on behalf of Mr. Howard is that the state introduced the testimony of an RN. It's Nurse Shuck in the trial. And what they did was they admitted the victim's medical records, okay? They say that the medical records are the expert report. And then they put her on the stand and she talks about some perceptions that she made when she examined the victim in the case, but she goes beyond that and she gives a number of opinions, which I argue are expert in nature.
Can you back up for 1 second? Because
Sure.
I thought that you're talking about they submitted medical records as the report. I thought they actually submitted a SANE report.
So they
changed that.
Yes, Your Honor, I'm sorry to interrupt. They did, so they introduced the SANE report. It's essentially, it's essentially the victim's medical record at the hospital when he's examined for a sexual assault. So it was the SANE report. But it's a little different than a typical expert report because you don't have where they're going to set forth their expert testimony. I will testify that the injuries here are consistent with being with a forceful penis in the mouth, or I will testify that the bite marks don't always manifest injury.
Are you saying that in a case like this that typically you would receive, in addition to the SANE report, which was the nurse's report when she did the examination at the hospital, the rape examination, that there would be an additional expert report that would be turned over by the prosecution?
Judge, what I'm arguing is that that's what should happen. Practically speaking, in court, that's not what happened. But I'm arguing that if you are going to have, okay, there's the difference, I'm arguing that between a SANE nurse coming in and saying, we collected a semen sample, we observed this, we observed redness on the throat, we observed a number of things, and we collected a number of things as a nurse, and that's what we do. I'm saying there's a difference between that, which would be perception, based on experience and what they do routinely at the hospital, and an opinion that says, these injuries are consistent with the victim's story. And so I'm arguing that when a state is proposing to do that by using the SANE nurse's testimony, that the defense should be put on notice so that they have the opportunity to obtain their own expert that may say the redness had other causes. I mean, the nurse even said that she ruled out illness as a causation of the redness to the back of the throat. The defense was not put on notice. They could have had an expert come in and say that redness can mean a number of things.
But wouldn't you have wanted to do that anyway? Whether or not there was an expert report that said it was consistent with her story, wouldn't it be to the defendant's advantage to have an expert that says, I've reviewed all these records and it is not consistent with any forcible act? And I mean, why wouldn't you have that expert anyway?
Well, Judge, and that's why I argued the ineffective assistance element and the assignment of error number 3 is because I also believe that because they saw that that the attorneys knew that the nurse would say that there was redness in the back of the throat, that there should have been some expert testimony on behalf of the defendant to show that could be caused by a number of things, or illness. I'm not an expert, but I'm sure that there could be some testimony that the redness was not caused by was not necessarily consistent with the victim's story in the case. And so that's why I raised.
But the state's arguing that this nurse was not testifying as an expert with regard to those statements. Those were lay witness opinions.
Correct.
Right. So how do you respond to that?
So I would differentiate her expert testimony from the lay opinion testimony. She gave a bunch of lay opinion testimony. I'll give you just a few examples that I was looking at this morning. She said there was tenderness to the palpation of the neck, that there was arrhythmia or bruising to the walls of the throat, that she took pictures of things that she observed. To me, that's lay opinion testimony. That's perception through observation. I think it goes much further when you talk about causation. That's what she's getting to when she says consistent with these injuries, consistent with this story. Bite marks don't necessarily show up in this manner. I'm arguing that goes more to the expert testimony. And I know that when the defense counsel raised the objection in the one point to Judge Shanahan, she said, you can't crouch this in expert testimony, but she let her testify anyway to it. And so it comes across to the jury as expert testimony, whether you say you can't call it expert testimony or not. And that's how the defendant was prejudiced by it. And
were the bite marks, was that testimony on direct examination, or was the bite marks a response to a cross? I'm trying to remember. You remember? Yes.
No, it has been a long time since I actually reviewed the entire jury transcript. I tried to make it through. I want to say, based off memory, that the bite marks were elicited from the victim on the direct testimony when the state was inquiring about the encounter itself. And the victim said that he had been bitten on his, I believe, hip. And then the same nurse testified that when it was elicited from the prosecutor, I believe that they don't always manifest themselves. It depends on how the bite is made, the time between the bite and when you go, how your skin responds to a bite mark. And that was the other point that I raised that I believe transgressed into the expert testimony territory and outside of perception.
Ms. Glazer, can I ask you a follow-up on that?
Sure.
If we had a case, let's say it was a child abuse case, and the child was examined by a nurse and there was bruising on the arm of the child, and the nurse testified that was consistent with someone striking the child. Is that really expert testimony, or is that something in the common knowledge of lay people? And is redness in the throat, is that expert testimony, or would an ordinary person know that there'd have to be something irritating it?
Judge, I would argue about your scenario with the bruising on the arm, that a nurse should be able to testify that they did observe bruises. Here are the bruises. These are the photographs of the bruising. If they are going to put forth an opinion that the bruising is consistent with what was the prosecutor is going to argue as a blow in a case. For example, in Boston, the court said that when the expert tester, or when the testimony from the detective said that the injury could have been caused by a belt buckle, that went into expert testimony category and not lay testimony. I would argue that saying that the bruise could have been caused by what the victim's story is, that if you're going to put forth that opinion, it needs to be set forth in an expert report prior to trial, so defense counsel is put on notice. And I do think that goes beyond perception, observation, experience. And especially with just a bruise, because it's something that can be caused by a number of other injuries, and it could have other causes. But Judge Myers, why I think it's so important in this case is because all this case came down to was just the testimony of the victim and the defendant, essentially. The argument's consensual sex, and this case was so close that the jury believed that they had consensual sex in one room. They moved to another room together, and they had almost simultaneous consensual sex. I mean, basically the men, I'm going to have to get descriptive, but basically the one man was on top of the other with his penis in his anus, And they're saying that that was consensual, but then when he ejaculated, he put his penis in the man's mouth, and that was not consensual. I mean, that's really what the jury verdict was. They found not guilty on 2 of the rape counts and only that count. And that was the count that the nurse testified about. She said that, because he jabbed it, there was redness in the back of the throat, and it was consistent with being forcefully jabbed by a penis. I think that's what really won over the jury.
Was the nurse's testimony or the opinions that you are disputing in this case, was that emphasized during the closing argument by the prosecution?
It was emphasized by the prosecutor in the case, and I think that that's akin more to what the initial case that all came out of the first district, the State versus Hall case, where the court really started to get into these expert versus lay opinions, and the defense counsel being put on notice with the expert reports. In that case, it was basically the theme, and the prosecutor drove it home by saying that it was consistent with the injury and the redness in the back of the throat, and I think it just tips the scale in a credibility contest. And without defense being put on notice, they don't have any way to counteract that in trial. The other issue I'd like to address, I apologize, I didn't look. How much time do I have? Am I getting close?
You have 2 minutes.
Okay, thank you, Judge.
Can you address the first assignment of error?
Sure. So what I argued in the first assignment of error is that there was a number of testimony from the detective about the things that they did to try to talk to Mr. Howard. It painted it, and Mr. Howard hadn't responded, okay? He doesn't have to respond to a detective. He didn't invoke at that time, as the state argues, but there was a number of repeated testimony about them trying to get a hold of him. He wouldn't speak to them, and that he wouldn't provide a DNA sample, okay? And the testimony was presented that they weren't able to clear him, and they had 2 stories, 2 sides of a story, which goes again to credibility. They weren't able to clear him because he didn't provide the DNA sample. And so it presented to the jury that he was not only not cooperative, but that he was refusing to speak with police. And I just argue that it violated, his right to remain silent, that he doesn't have any duty to speak with the police. He doesn't have any duty to provide a DNA sample. This
was just testimony about them trying to locate him. This was not testimony that he invoked his right to counsel, invoked his right to remain silent. It was testimony about them trying to locate him, right? And find him in order to interview him.
Yeah, some of the testimony could be framed in police investigation procedure, but I think it went beyond that when they talked about wanting a DNA sample from him, and the fact that they weren't able to obtain one because he wouldn't consent to give one. I think silence and the refusal to provide a DNA sample can be compared to invoking in some ways the right to remain silent, because it shows to the jury that, in a trial, you're not allowed to talk to the jury about, the police wanted to talk to the defendant and he refused to give a statement. Okay, when you do that, it could be a mistrial. All right, and I've seen it happen. And you're not allowed to talk about a defendant's right to remain silent. Here, they didn't say that he necessarily told the cops, I won't talk to you, but they went through about 10 different things that they did about going to his church, leaving letters, calling his mom. He didn't want to talk to him. He didn't want to talk to him. And then we just wanted a DNA sample. He wouldn't give us one. And he doesn't have any, it prejudiced him at trial because it presents to the jury that he's refusing to talk with police and that he's refusing to cooperate, refusing to give a sample. And he doesn't have any duty to. It's the state's burden at trial, and it shifts the burden. It makes it look like he somehow has some requirement to speak with police when he doesn't.
Does the fact that he later testified clear any prejudice? Because I believe the state, they can ask him, right, in cross-examination about whether he was evading the police. So he later testified in this
Yeah.
case.
Right. He did testify, Your Honor. And I don't know that his testimony necessarily clears the prejudice to him, because when the detective testifies it and it's elicited already on direct, it's put him at a negative. It shifted the burden to him. When he goes up to testify, he now has the burden of arguing to the jury that he did not evade, or he did not, why he didn't provide a DNA sample. And so it shouldn't have been elicited on direct. If when he came and when he testified in his own defense, he surely could have been crossed about it once he started talking about his statement and his interaction with police and the fact that they tried to interrogate him improperly. But it should not have been elicited from the state on direct. And I think it shifted the burden, and I think it violated his constitutional right.
Thank you.
Thank you, Judge. I'm sorry, do I have more time?
Well, you have your 3 minutes that are reserved.
Okay, thank you, Judge. Sorry, I thought I was out. Okay.
Counsel, whenever you're ready.
Good morning. May it please the court.
Good morning.
Let me start with the second assignment of error. Judge Krause, like you said, the state's arguing that although Nurse Shuck was certified as an expert, the testimony that she was giving was non-expert testimony that was admissible under Evidence Rule 701. Pretty much everything she was testifying about was what was in her SANE report. You'll see when you look at, I think it's Exhibit 3, and then they also added Exhibit 11 because one of the pages was missing. You'll see that she kind of marked on a diagram where Ira Thompson had said that he was injured in different parts, you know, whether he was nibbled on the neck, parts on his body where he said that that Howard had bitten him. And she just said when she was testifying that, you know, she saw redness in his throat, and that was consistent with the narrative that he was giving in the hospital. Counsel for Howard didn't object until the prosecutor asked if she had an expert opinion about what caused the redness. So what counsel did was object when she was going to get into any causation, that it was caused by a penis being forced into his throat. And that's where it stopped. Judge Shanahan said she's only testifying about what's in her report, but to the extent that she would talk about causation, then it would be expert opinion and she would sustain the objection. And then she went on, the next bit of testimony she gave was about ruling out illness as a cause of sore throat. Which,
isn't that an expert opinion though?
I think that that's probably more in line with the 701, although it's different from the cases, you know, as far as like police officers being able to say that some mark on someone's arm was someone stomping them or something like that. I think that that's kind of the epitome of what a nurse would know from perception. I think actually a lot of moms would know that, right? If you look in your kid's throat, you know, flash a light down there, you know what a sore throat looks like.
But she specifically, I mean, I think in this case, and correct me if I'm wrong, she said that she ruled out that the injury came from illness, right? And then she explained why she believed that. I think she said illnesses present more generally, or I don't remember what it was. So, you know, just in looking at that, I don't have a lay observation, right? This would be a medical professional examining an injury and explaining where she believed it came from, right?
Right, I understand that. I do think that a lot of that is something that you can just know through observation, and she just knew that from her experience, not necessarily as an expert of specialized information.
Can I ask one more question on that? Yes. When you're talking about lay testimony, and I understand your argument on that, but you have in this case, you have somebody who's qualified as an expert witness, you know, versus some of the examples that you gave with police officers saying that an injury would be consistent with the victim's narrative of the events. In those cases, the police officers were not qualified as experts, right?
Right.
And so you have an expert or somebody that's qualified as an expert giving this opinion. But then when I was looking at the transcript, the prosecutor actually asked the nurse, do you have an expert opinion about the injury, right?
Yes.
So they asked her in her expert capacity.
Yes.
And so I guess, how do we remove that from the expert realm when that's how the question was asked?
Well, and that's when counsel objected, right? And the court stopped the questioning and said that to the extent that she would be giving an expert opinion, she would sustain the objection. And there was no further discussion after that.
Was the jury instructed that the next testimony she was going to give was not going to be in her expert capacity?
They were not instructed, but also there was no request for it. You know, once the court sustained defense counsel's objection as to the any expert kind of nature question, then it just went on. And when Nurse Shucks started talking about whether or not it was consistent with an illness, or if she could rule out illness, there was no objection made to that testimony, which immediately followed the discussion at sidebar about the question about the expert testimony. And also, one thing to note, even if this were, and I maintain that this was not expert testimony, but even if it were expert testimony, if you look at the standard that was laid down in Hall, the three things that we look at, you can't say that Mr. Howard was prejudiced by this, especially since in his interview with Detective Woolner, he admitted that he did in fact grab Mr. Thompson's head and jam his penis into his throat. It was just more a matter of how each of them were taking it. Mr. Howard was maintaining that it was passionate, as opposed to obviously Mr. Thompson, who felt that he was being forced to do it. So
isn't that sort of the point of defense counsel's argument that this is the charge that he was found guilty of? And I think what her argument was that's, you know, thereby the prejudice.
Right, but here Mr. Thompson or Mr. Howard was admitting that he did exactly what, I mean, even if you believed Mr. Howard, Mr. Thompson would have redness in his throat, because Mr. Howard said that that's what they did when they were having oral sex, that he jammed his throat and that it was a little rough. And the same thing with respect to the bite marks, which I think to go back to a question you had asked Judge Krause, the nurse Shuck had kind of mentioned the bite marks. I think they got more into it on cross-examination about whether or not you could tell a nibble from a bite. And then
that's what I thought. Yeah, when I read the transcript, I thought that particular expert opinion came out in response to cross-examination, but I'd have to look again.
Right, I think that's true. And I was trying to look and I couldn't find it, unfortunately. But I do know that then on redirect, the prosecutor went into it more. But again, any of that testimony was consistent with actually Mr. Howard himself said that he did give a love bite, or I think he called it a love bite, and then he calls it a passion mark on Mr. Thompson's right hip. So really, it's the same. You're still wondering whether or not any of this was consensual. And again, it is down to the two witnesses and the credibility, but there was a lot of credibility. And I talk about with respect to the last assignment of error, there was a lot for the jury to judge as far as whether or not Mr. Thompson was credible, especially since he went immediately to the hospital afterwards. That kind of discredited Mr. Howard's defense that this was kind of a scorned lover, kind of that Mr. Thompson was hurt, that somehow they weren't going to have a relationship. And then he went pretty much after it happened, you know, after going home, then he went. So I think that as far as credibility, once you look at both of them, the credibility weighed and the jury weighed the credibility in favor of Mr. Thompson. And I don't think that any of that, I think you have to separate out what the jury decided on the other rape charge as far as the anal sex. I think that just because the jury acquitted on that charge doesn't necessarily mean that they believed that they were having consensual sex at one point and that it turned non-consensual. We have no idea why the jury acquitted on the other rape charge, and you can't read into that what they did. I'd like to move real quickly to the first assignment of error. Like I mentioned in my brief, most of the statements, there were no objections to it. And really it was just Detective Woolner talking about the course of the investigation. Only on page 806, where he started to say, he said, I'm aware at some point, slightly before he was actually arrested, contact was made between law enforcement where he was advised to contact me and he didn't. There was an immediate objection and the court immediately sustained that.
What was I'm trying to understand the reason for even bringing this testimony up by the prosecution about the course of the investigation and trying to get a hold of him, because in reviewing the case, I don't think that the defense was arguing anything about there being a sloppy investigation or anything like that. So it just kind of comes off as the prosecution trying to get out that he's avoiding the police, basically.
Well, I think there are two reasons why they may have brought it in, and obviously I'm not exactly sure. I think first of all, you have the whole, you get to give the jury the whole picture, right? And so you get to, you don't have to just, you get to give the jury your narrative of explaining how the investigation came about, right? And I think also, even though there wasn't an argument made about the delay, Mr. Howard wasn't talked to by police, I think, until a year after this. I think that the interview with Detective Woolner was almost exactly a year after this, or maybe a year and a month. And so there is a chance that even if defense counsel didn't make that argument, you might wonder, you'd have the jury looking at that and they would, kind of do the math themselves and figure that it's been a year. And you can figure out why has it been a year that they waited to talk to this guy. And if the jury was wondering that, it also played into the defense counsel's part of their version, which was that it was only because Thompson was upset that they weren't going to have a relationship, and this was a scorned lover, so it took a while to develop. Whereas by talking about, the attempts that they made to find him, I think at least allayed some of that from the jury's concern. And
Counsel, what isn't this different though in a case, let's say he had fled to Mexico. There'd be an argument that you could inquire as to that, and then at the end of the case, ask for an instruction on flight as to consciousness of guilt. But that's not what we have here. I mean, their attempts to locate him don't mean he was fleeing or trying to flee the jurisdiction as evidence of guilt. So why isn't that improper as argued by the appellant?
Well, I don't think that it's improper just to set up and there's always, often in jury trials, there's a discussion about the course that the investigation took. And for whatever reason, in this case, there were a couple of other, I think at first they had to ask Detective Woolner about his investigation because it was assigned to one detective first. And so he was talking about that detective's notes as he was going in and investigating it. I think too, unfortunately, I think the other detective who was assigned with Detective Woolner maybe was sick with cancer. And so Detective Woolner was explaining what he did to take over. So I'm not sure, like I said, I unfortunately can't get in the head of what the felony prosecutor was thinking, but I'm thinking that they just wanted to set up the narrative. And really this wasn't a large part of what Detective Woolner's story was. And also on during closing argument, I read through the closing argument again yesterday, and I didn't see any reference to any of the delay. Like, I don't think that at any point the state kind of emphasized that.
And that's important in our harmless error or plain error analysis, right? I mean,
Yes.
This was not a central part of the state's credibility or argument that Mr. Howard wasn't credible.
Right. And if I could just real quickly just touch on the whole question of the DNA.
So you have 2 minutes left.
Okay, thank you. I don't think as far as the DNA, there was no testimony that we tried to get his DNA and he wouldn't give it to him. Instead, it was, again, as part of the conversation, the prosecutor asked, well, what did you do? And what did you do? And the Detective Woldner said, well, we wanted to get some DNA. And she said, did you ever get DNA? Yes, we got it subject to a subpoena following his arrest. It wasn't that he had refused to give his DNA. It was just part of, regular police work that they got his DNA and then how they tried to match it up with any of the samples that were taken from Mr. Thompson. As far as the other assignments of error, I kind of already touched on those. Obviously his statement to police was admissible as a statement against his interest. And there was plenty of evidence here to support both of the offenses for which he was convicted, the rape and the felonious assault, for not reporting that he was HIV positive. So if there are no other questions, I'll submit my brief. Thank you.
Thank you.
Is the court ready for me to proceed?
Yes.
Okay, thank you. I just want to briefly touch on the second assignment of error, just because we talked, spent the most of the time this morning talking about that. But I would say that the lack, I was thinking about this as the state was talking about, the case in Hall again, when it initially started this expert report, requirement of the state, because they had been getting away with this for quite some time. But the testimony about the lack of a physical manifestation of a bite mark, to me, is very much akin to a detective talking about delayed disclosure in children, and how, they may not be able to talk about it right away because, for a number of reasons, and they make the disclosure much later after the incident happens. And that's what I think the bite mark testimony reminds me of. It might not be there right then. It may manifest later. It may not manifest at all. It's a delayed reaction to an incident. And I think that's what, the testimony about the bite mark reminds me of.
Ms. Glazer, if we agree with you that this was expert, not lay opinion, how do you respond to the state's argument that this was not prejudicial because Mr. Howard admitted to these things? He admitted that this was rough sex and that he jammed his penis into the victim's mouth. He admitted that maybe he didn't bite him, but that he certainly gave him a passion mark or something like that. So this was all admitted by the defendant. So how is this prejudicial?
Judge, I would argue it's prejudicial because it came down to this credibility of he said, okay? And you have one person who says, Mr. Howard says, it may have been a little bit rough on him. And you have Mr. Thompson saying, he jammed it in my throat forcefully, it was painful. So you have that and that. And then the other scenario is you have, I nibbled on his neck because it was a passionate experience in the living room. And Mr. Thompson, who says he suffered a forceful bite. Those two things are really the only physical, or what could be considered the physical evidence in this credibility contest. And when you have someone, the jury, they spent 12 pages or so qualifying her as an expert, talking about her training, her experience, how many people she's seen through the course of her SANE examinations, saying that the redness was consistent with his story over Mr. Howard's, and that the bite mark probably was there. I mean, she didn't say that verbatim, but yeah, there could have been a forceful bite mark. It just doesn't manifest maybe on him because of the kind of skin he has, or because his skin reacts differently. Those are key determinations in deciding what he said was whose story you believe. And I think that those were two very important pieces of evidence. Although Mr. Howard says it was consensual sex, he still suffered prejudice because those two pieces of evidence are the only thing the jury could have said that made Mr. Thompson's story more credible than Mr. Howard's. And the jury is going to give anybody who's qualified as an expert that weight greater than the two witnesses that took the stand, in my opinion. And that's what really tipped the scales in this case, as I mentioned earlier, because you can look at the verdicts and see that just the simultaneous act of the anal sex followed by the jabbing of the penis. They believe that, and that really comes down to those two pieces of evidence. That's how I think he was prejudiced. My apologies.
Let me follow up real quickly on what Judge Krause just asked. Yes. Isn't it consistent with your client's credibility as well, though? Couldn't the jury have found that the SANE nurse bolstered that credibility because it was consistent with your client's story as well?
Okay, Judge, so to answer your question, so you're saying that the SANE nurse testified that, well, she testified on cross, I believe she indicated there was no evidence. She admitted there was no evidence of the bite mark. But it was the prosecutor eliciting the testimony that just because there was no bite mark doesn't mean that it didn't happen. It's just like saying in a SANE examination of a child in a sexual assault case, there's no DNA because we never find DNA in these cases. I mean, 99.9% of the time there's no DNA because there's delayed disclosure, and the kids don't always exhibit, anal fissures if they've been raped anally, and there's never any.
The difference is, Ms. Glazer, the difference is that Mr. Howard, while he did not admit to actually biting, he did admit to doing like a passion marker or doing something that would irritate the skin, right?
Right.
So it's consistent with what he admitted to, which is what the prosecution's arguing for both of the expert opinions.
So Judge, even if you don't find it was prejudicial on the aspect about the bite mark necessarily, I still think ruling out the illness was certainly an expert opinion, and that it most certainly prejudiced, I can't get that word out this morning, Mr. Howard in his defense, in that they weren't given proper notice. It wasn't in the report. I had to argue the ineffective assistance because yes, it was in the medical record that there was redness in the throat. But having an expert come into court and testify that that the illness could have been caused by other things would have, I think, certainly made a difference in this case. And I don't think the introduction of the illness, not only was it not proper, but I definitely think it prejudiced Mr. Howard in this case. And I think it tipped the scales on the count that they found guilty on.
Thank you, counsel. Thank you.
All right. Thank you, Your Honor.
Thank you for your arguments. We'll take the matter under submission and issue a timely decision, and have a wonderful afternoon.
Thank you. You do the same.
It was great seeing both of you.
You as well. Thanks.
Good morning, counsel.
Morning, Your Honors.
Good morning, Ms. Bichard.
Good morning.
So the second case we have is Andrew Richard versus Bank of America. So the way that we start is that each side will introduce themselves and their readiness to proceed. And we always start with the appellant. So if you can state your name and your readiness to proceed. Ms. Richard?
Yeah, sorry, I'm trying to get back.
That's okay.
So my name is Angel Richard. I am the appellant. I am starting a case against Bank of America because of breach of contract and their actions towards me.
Okay, and you're ready to proceed today.
And I'm ready to proceed.
Okay, thank you.
Good morning, Your Honors. Jessica Johnson for Applee, and I am ready to proceed.
Okay, so Ms. Richard, you have 15 minutes to argue your case. You can reserve whatever amount of those 15 minutes that you like, and in order to rebut, in other words, after Attorney Johnson has argued her case, then you can reserve time to then respond.
Okay.
So the first question that I ask you is, how much time would you like to reserve?
I would like to reserve around 10 to 15 minutes, most
Okay.
of my time.
So let me make sure that you understand. So you have 15 minutes total regardless, okay? So you can start off with whatever amount you want, and then the reserve time is your response time.
Okay.
So for example, if you were to reserve 5 minutes, for example, you would have 10 minutes. And then after Attorney Johnson, you would have 5 minutes.
Okay.
And you get to reserve whatever amount of time that you like.
Okay.
So how much of the 15 minutes would you like to reserve?
I would say probably 8 minutes.
Okay, so that gives you 7 minutes. All right, and you can start whenever you like.
Okay. I came to the court, my name, Angel Richard, came to the court in search of getting retribution because of the breach of contract with myself and Bank of America. I currently have a loan with them for my 2017 Honda. I was trying to register my new title in Ohio since I moved out here for work. And
Now, were they the initial lender? Were they the ones that you took the loan out with originally?
No, the initial lender was Santander.
Okay,
They bought out the loan from Santander
okay,
and moved on to themselves. I proceeded to try to get a new title because I had to switch it over from Nevada to Ohio. And they stated they did not have the title at all. That it was in line, I guess in their opinion, for me to receive the title since they paid the new loan off to have the new lien holder on it. But in the state of Nevada and the state of Ohio, when the lien holder buys out the lien from the other lien holder, it goes straight to them. And I continuously paid with them for my car, which they didn't have no title for 6 months. And I wasn't able to do anything. And in that process, I was being harassed by a couple of their employees, one being Eric Day, for the fact of not having the title, to where they stated that they wanted me to pay off the complete loan or they would impact my credit. Me being just a young person with a car loan, I had no idea what to do. So I wanted to contact both BNB and DNB to ask what to do. And then once their harassment continued, I went to the court case to figure out what to do because I feel like they were in breach of their contract with the fact that they never received my title supposedly or lost my title. And then were harassing me and threatening me on the fact of me being in breach of contract with them when the title should never have came to me. I am asking for restitution in the amount of $8,000 in the aspect of the money that I have paid them for my car, as well as insurance I had to have on them, expecting to use my car, as well as having to live closer to my job since I wasn't able to work. And I'm, again, very new to Ohio, so I had no idea what to do, and it was my only way of transportation. I really honestly just want to know what to do and figure out the best method in this. I don't want to be harassed anymore, and I just want to go about this in the best possible way.
okay.
So, Ms. Richard, is what you're saying that you were unable to register the car in Ohio because you didn't have the title to your car and they didn't or couldn't give it to you?
Yes, I tried to register my car in Ohio, and with BNB states that the title has to be transferred from the original state that I was in to Ohio. So when I contacted BNB, my lien holder, to get the title, they stated that they never received it and that it was my fault for that. But I was told by BNB of Ohio and of Nevada that since they were the lien holder and they bought out the original lien from Santander, that it's supposed to go electronically to them. And they say that they never had it and it was my fault and it was supposed to be shipped to me, which in 2 different cases, it's completely wrong that it was supposed to be sent to them.
Thank you.
And has this matter been resolved with regards to the title?
So I was able to get a new title sent to me with me being the only person on it since I had to get the new lien release on it. I was able to register it when I went back home in with COVID, it wasn't until about a month or two ago. So for a year and four months without COVID being involved, I wasn't able to use my car because
Okay. So in your complaint, when you say making me pay for a duplicate title, you were just saying that they were making you pay it, not that you had in fact had paid it at that time.
Yeah, they were asking me to pay it. They stated that all the fees on the end of me not having a title or them not receiving a title, that I had to pay all of the fees forward because they stated that it was my fault that they did not receive the title. And I asked if they would be able to reimburse me, and they said no, that in the contract, I have to pay for everything, which I believe I submitted the original contract.
All right, thank you. Attorney Johnson?
It please the court. My name is Jessica Johnson and I represent Appley Bank of America. In this case, the trial court granted Bank of America's motion to dismiss plaintiff's complaint pursuant to 12b-6 for appellant's failure to state a claim upon which relief can be granted. In appellant's brief, she argues that she was not properly notified of the motion hearing before the trial court and therefore did not have the opportunity to present her evidence in support of her complaint. However, even if appellant had appeared at the hearing and presented her alleged evidence, it would not change the fact that the complaint filed in the trial court fails to state a claim against Bank of America.
Ms. Johnson, can I interrupt you and ask you a question?
Yes.
She did allege in her complaint that there was a contract between your client and her, and Rule 10 arguably would have required her to attach that contract to the complaint, which she didn't do. Isn't the remedy of your client to seek a more definite statement and require her to attach that contract rather than a motion to dismiss?
Your Honor, I agree that is an option. However, the elements of breach of contract, we do not believe that any of the 4 elements for breach of contract were sufficiently pled in her complaint at all. So rather than file a motion for a more definite statement, we decided that the best avenue was to file a motion to dismiss just because we do not believe that one element was satisfied.
Thank you.
So Bank of America would request, therefore, that the appellate court affirm the trial court's decision. I guess my first point in her brief, and I will say all of the things that Ms. Ricard said right now, none of that currently is before the court in any capacity. I don't believe a lot of the facts that Ms. Ricard recited just now were contained in her brief. Some of it is new information to me.
Well, she does talk about quite a bit of it through her discussion of damages. I mean, a majority of her complaint is really focused on discussion of damages.
Noted, Your Honor. I thought the majority of her brief was really just arguing that she did not have sufficient notice of the motion to dismiss hearing. Appellant and appellee appeared before the trial court on October 3rd, 2019 to discuss the case. A case management order was filed in the trial court based on that discussion, and the motion to dismiss hearing was noted at the bottom of that case management order in which Ms. Ricard signed. So we believe that she did have sufficient notice. We did appear at that motion hearing. And then further, like I stated earlier, even if she did have notice of that, we do not believe the 4 corners of her complaint properly satisfied the elements of breach of contract.
Which element was missing, do you contend? Because she alleged a contract. She didn't attach it, granted, but she alleged it.
She alleged there was
damage and breach, didn't she?
She alleged that there was a vehicle loan with my client. She did not allege that she performed the contract.
You don't have to allege that, do you? You might have to prove it, but is that an element of breach of contract? Isn't it just contract, breach of contract, damages proximately caused thereby?
The law that we cite in our brief, and I believe it's out of the first district, is the party needs to show that there was a binding contract between the two parties. Ms. Ricard really only states that there was a vehicle loan, that the non-breaching party performed under the
Well, let me
contract.
stop you there. Only says there's a vehicle loan. Isn't that a contract? Doesn't your client view that as a contract?
I suppose, Your Honor. However, like you stated, it was not attached, so we really didn't know exactly what, was being referred to. Further, she doesn't state that she was not in breach of the contract. That the third element was that the other party breached without legal excuse, and then that the non-breaching party suffered damages therefrom. So it was
But
those-
as I understand, her allegation is she had a loan that was purchased by your client. The original lender held the title. She needed the title when she moved states, and that happened after your client bought the loan. And she had no way to do it, and your client told her that they didn't have the title. Why isn't that sufficient, if that's what's alleged in the complaint, sufficient to allege a claim for breach of contract?
Your Honor, I know this isn't before the trial court or, in front of you, but Ms. Ricard, the contract states that there are certain things that the borrower needs to do. And
But then you're conceding there's a contract. I mean, then you see where I'm going. I mean, it becomes kind of a circular argument. Either there is a contract with her or there isn't. And your argument, I think now, is going to be she wasn't paying on the loan.
well, there's numerous things, but to go off of the things that are in front of the court, we do not believe that the trial court erred in granting the motion to dismiss based on the complaint that was filed by appellant.
All right, thank you.
Thank you. Ms. Richard,
Yes, ma'am.
you had reserved 8 minutes, and you didn't use all of your time at the beginning, so you actually have 9 minutes.
Okay. Going based off of Ms. Johnson's comment, I did not receive the notification. I have multiple paperwork in front of me that I can submit to you that's stating that multiple of my scheduling has gotten canceled. And I have a paper right in front of me that I can also submit that says the mediation date should have been on 11/18. And I was informed about that. I have the paper for that. And then I have 2 more papers stating that my original scheduling was canceled. So I feel that if I would have been able to be there and present my case, that we never would have gotten to this stage. And I would have been able to have more timely manner in being able to submit everything and prove my side of the case.
I want to make sure I understand what you're saying, because I'm looking at the case management order, okay? And at the bottom, it says there's a hearing date scheduled for November 14, 2019. And I see your signature. So when you signed this, was this notation already here?
I believe it what should have been, because I know when I was there, I was confused and I was
Okay.
asking since I've never had to go into the court, what was the ruling, that I was probably very confused because I had another paper that was sent to me for 10/13 saying it was canceled. So I, honest to God, believe it was the fact that I was confused on it being the 13th or 14th and seeing that on the paper said that it was canceled, that I coincided both, thinking I believing that I only had the mediation.
Okay.
I can't
So
even
you're
find
saying
the
is that
original.
with the notifications you received thereafter, you understood that to mean that this 11/14 date was canceled, was no longer at play?
Yes.
Okay, thank you. Thank you for the clarification.
In regards to more comments on it, I honestly feel like the breach of contract was more on the side of the Bank of America. I don't know how I would have breached the contract when I signed the contract and agreed to pay, and when I didn't have a title. I felt like if they didn't own the title, then who was I paying the money to?
Yeah, and
And
I'm gonna, just to clarify what's before us. So you filed a complaint
yes,
and the trial court had dismissed it under 12b-6. And ultimately what the trial court is saying is that the complaint that you filed, um, that there wasn't sufficient in there to be able to raise a claim that the court can hear. And so that's why it was dismissed.
Okay.
Okay, so, you know, what's before us isn't whether you should have ultimately won the case, it's whether the complaint should have survived or should not have survived the ruling of the motion on the 12b-6.
Okay.
Okay?
That's all I have to say then.
Okay, all right, thank you. Okay. Thank you for both of your arguments this morning. We're going to take the matter into submission and issue a timely decision. And I wish you both a great afternoon and keep safe.
All right. Thank
Your
you.
honors, have a great day. Bye-bye.
Thank you.